Good afternoon, guys. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, we're going to talk about removal proceedings. Of course, we're talking about it because immigration courts are reopening. Immigration courts are reopening, and I have a video on how to prepare for your immigration court hearings and to prepare for reopening. And this video is going to be about what to do if you're placed in removal proceedings. I'm going to cover what forms of relief may be available, what to look for when you are choosing an attorney to represent you, and I'm going to share with you some tips that maybe even some lawyers are not fully aware of. So please, if you have not subscribed to my channel yet, please do so and hit that notification bell button so you will stay updated with regard to the most up-to-date immigration news and will receive the best immigration tips on YouTube. So thank you very much for joining me. Let's start. When you are placed in removal proceedings, ordinarily it will happen perhaps if you did not pass your asylum interview, and don't get upset. It's very common if after asylum interview you are not receiving asylum and rather referred to court. So it's something to know about, it's something to get prepared for right away, even though it is upsetting. It's not the end of the world, because in immigration court you will have an opportunity to present your asylum claim before the judge de novo, or again. Immigration judge, even though he or she are going to have a copy of your file and of course prosecutor's notes, asylum officer notes from your file, from your immigration interview, has to make a new determination about your case. So you will be able to supplement the records, prepare better, and present your case again. All right? So don't be upset if you are referred to court after your asylum interview. But this is one of the ways to be referred to immigration court. Sometimes you just get in the eyes, outside of the radar, you get in the radar of immigration authorities. Why? Because maybe you filed for some form of relief and you were denied. Maybe you overstayed your F1 visa and your school sent a notice to the government, to immigration authorities, alarming them about the fact that you are no longer an active student and you're going to receive a notice to appear. Notice to appear can stem from criminal charges. Let's say you were charged with a crime and ICE also received a notice of that, or somehow discovered your situation and now you are charged with also inadmissibility and removability, and you're placed in immigration court proceedings. But these are the usual reasons as to why you would end up in immigration court proceedings. Immigration court proceedings are federal administrative proceedings. The judges in immigration courts are administrative judges, but unlike federal judges, what we call Article 3 judges or magistrates, they are administrative judges, and technically they're not, unfortunately, fully independent. They are under the roof of EOIR, or Immigration Office of Immigration Review, and they have to follow Attorney General orders. So this is the difference between immigration judges and federal judges, even though they also have to follow federal judges' rulings in the districts where they sit. Very important, maybe important for your case when there is a legal issue that may be resolved differently. Let's say if you are in New York and you're in New Jersey, the same legal issue can be resolved differently in certain situations just because there is different federal law regarding it. So you are in removal proceedings. What are you going to do? Well, first of all, of course, you have to know when you have to come into court. It's extremely important, because if you would like to fight those proceedings, would like to have a chance of staying in the United States, you do not want to miss those court dates. Second most important thing that you will have to do is to determine what is it that you're going to be filing for. What is it that you're going to be filing for? How are you going to be defending yourself? And this is, I would say, one of the most important parts of your case. You have to sit down with your attorney and see what are eligible reliefs you may be able to file for. And I'm going to mention now the most common reliefs: asylum, withholding of removal, convention, and relief under Convention Against Torture. Cancellation of removal. Cancellation of removal for non-permanent residents. If you've been in the country for 10 years plus, if you have qualifying family member, if you're a person of good moral character, did not commit an aggravated felony. Waiver of fraud. For example, 237A1H waiver may be available to those who are being placed in removal proceedings after they did not win their I-751 form. In certain situations, you may file for a waiver in immigration court rather than trying to come up with something else. 245I adjustment. 245I adjustment, guys, and I have a good article about it, may be available to certain people who were dependents or relatives of principal applicants when qualifying family or labor petition or labor certification was filed for them. Why am I focusing on this specific thing? Is because sometimes people are unaware that they may qualify for relief because it was not them, but rather their former spouse or parent was petitioned a long time ago for something. It's very important thus to verify if you may be able to benefit from an old filing that was done for your former spouse. Let's say you're not married to that person anymore, but you were married to that person at the time he or she was being sponsored by a company. And guess what? Even though you guys are divorced now, you may still be able to benefit from that filing possibility. Vow cancellation of removal, U visa. Now, vow cancellation of removal. I want you a little bit focus on that specific relief. Why? Because it may be available in hard situations. Let's say somebody entered on a K-1 visa, right? And even though you married the petitioner, you became married spouse, but you never filed, he never submitted forms, or she never submitted forms for you to adjust status. And hence you are stuck in this K-1 situation or K-3 situation. Sometimes you cannot adjust based on a petition by someone else, by a new spouse, or even a self-petition. But you may be able to file for vow cancellation of removal. Vow cancellation of removal may also be available to lawful permanent residents. Interesting, right? You will have to show that you were a battered or abused spouse, that you've been in the country for 3 years prior to application for vow cancellation of removal, you're a person of good moral character, and you're going to suffer extreme or unusual hardship, extreme hardship to yourself or your qualifying relative in case of removal. This is something not to be overlooked when we are screening a person for potential relief in immigration court proceedings. Some people actually do not know about it. Of course, it's a little bit confusing. Vow cancellation of removal is listed under the section for non-permanent residents, and hence sometimes it can be overlooked for permanent residents. Very, very important. And these are the most common forms of reliefs, but not all of them. Far from being all of them, guys. Again, not only your situation, your family member situation has to be analyzed, and your past family member situation has to be analyzed to determine if you can file for something. But what if you're a person who has nobody here? No child, no parent, no spouse, no ex-spouse. You've never been a victim of a crime, but maybe you've been here for like 30, 40 years. It's not unusual. You've been working, paying taxes. Maybe you have your own business, small or medium size. What are you going to do? Well, in this particular climate, in this particular situation, you may try to go for prosecutorial discretion and just prepare your case as well as possible. As much preparation as possible has to go into it, arguing before the prosecutor that perhaps your case should be paused or terminated, even though you don't have any viable relief, but you are a good person of good moral character. Maybe you're volunteering, you have a business, you've been sustaining yourself and your employees, and maybe in the future, especially nowadays when we have talks about immigration reform and possibilities of various reliefs for, let's say, essential workers, Maybe with time you will be able to qualify for something. But this is like the last resort if you cannot qualify for anything else. Now, what to do if you have a very weak application? Let's say your lawyer says, listen, you have a very weak application. Shall you proceed with it? Yes, of course you should, right? Even if you have a very small chance, my position would always be you have to file for it, even if you have a small chance. Let the judge rule you out. Let the judge decide that you don't qualify for it and you don't have enough evidence, rather than not even try, okay? But we're not talking about frivolous applications when we know that everything is made up. No, of course not. We're talking about weak, truthful applications, all right? There is a big, huge difference between the two. So once you determined that this is the relief that you're going to be filing for, your lawyer is going to discuss it with you and put it in pleadings. Pleadings are your answers to the allegations in the notice to appear. And you have to screen that notice to appear carefully. There may be mistakes in it. Perhaps it lists wrong country or wrong entry date, which may be crucial for your potential applications. But that's how it's going to go. You're going to basically enter your pleadings, and you have to be aware of them, guys. It's very important. I know that some people don't know what pleadings are and what is it they're going to be filing for in immigration court. It's very important to know what you're filing for, what you need to win that application, and what's the correct name of the relief. So if you do need to seek a second opinion, you will be able to ask an attorney as to what your other lawyer is proposing for you to file, right? So write it down for you. It's better if your lawyer prepares such pleadings in writing and you receive a copy of it, all right? So you know exactly what's going on in your case. And of course, afterwards, all your efforts should be, or majority of your efforts should be designed to prepare to win your case, okay? Cases are usually won if they are well documented, if you are a good witness in terms of you can answer the questions clearly, concisely, all right, and understandably. If you are someone who would like to start from the date you were born till today, when you're talking about a fact that has no relevancy at all to the date when you were born, you're going to have a hard time in immigration court, because immigration judges would like to have concise, precise answers to their questions. All right, you have to be preparing, providing documents, staying in contact with your attorney reasonably, of course. You have to be filing your taxes. One of the things that I've noticed, people are very relaxed sometimes about their tax returns. Nowadays, you can get, even if you don't have a social security, you can get ITN number very often. Of course, you have to work with your accountant on that. Taxes is the first thing that judges look at, regardless of what you're filing for. Even in asylum filings, in asylum cases, I've noticed that judges may request you to present your tax returns. Okay, very, very important. Tax returns, employment records, volunteering records, very important. If we talk about hardship, guys, medical records, affidavits from your witnesses, even though you may call them to court, but you would like to be prepared. Why it's important to submit affidavits or statements from the witnesses ahead of time? Sometimes it will help you to negotiate the case and perhaps close it or make your trial very easy, right, with a prosecutor, if you have good detailed statements from your witnesses. Just keep it in mind. So it takes a lot of preparation in the case. And one last part, you must be truthful. Sometimes there are situations when you don't have relief, you cannot win your case. But if you are truthful, if you're sincere, if you are not someone who are holding back the records, that even if they may be not good for your case, but you have to produce them, the judges and prosecutors will appreciate it. Okay, just remember that. So it's important to choose the right strategy for your case. It's important to be truthful, be thorough in preparation, and most importantly, you need to know what is it that you're filing for and how to prepare for it. Okay, very important. Well, hopefully you will find this video helpful. at least it may guide you in search for the right answers in your particular case, or maybe in preparation. We never know what's there to come. So you have to be prepared for anything, especially if you have a family in the United States, you have children. You guys have to prepare that any day you may have to present those records, either for defending yourself or for applying for something in case immigration reform will pass. Well, thank you very much for watching, guys. Please like, share this video, and subscribe to my channel. I hope to see you soon.